Good evening, dear students. Yesterday, in the Medical Termination of Pregnancy Act 1971, we had seen the objective and the purpose of the act, right? And we have also seen why there was a need of the Medical Termination of Pregnancy Act 1971. So we discussed Article 21 of the Constitution of India, and we also discussed a judgment related to Medical Termination of Pregnancy Act 1971. Now, today we are going to start with the act and the provisions related to it. So, moving ahead, first of all, let's revise what section 312 of the Indian Penal Code is. We all know that section 312 of the Indian Penal Code talks about causing miscarriage, isn't it? Like it says that whoever, voluntarily causes a woman who is carrying a child to miscarry, right? And if such miscarriage is not caused in good faith for the purpose of saving the life of a woman, then it is an offense and it shall be punishable with imprisonment, right? It may extend to 3 years or with fine, or it may extend to 3 years along with fine, right? And if the woman is quick with child, then also there is punishment, right, of either description, which may extend to 7 years, and also there is liability of fine. And section 312, the explanation of the section, it says that a woman who causes herself to miscarry is within the meaning of this section. That means there is an offense and she will be punished for this if she herself causes miscarriage. So that means causing miscarriage is an offense if it is caused voluntarily, right, under the Indian Penal Code. So if the conditions of section 312 are fulfilled, then it will be an offense. Now see, in 1971, a law was enacted by the parliament, right, called the Medical Termination of Pregnancy Act 1971. Now, since section 312 of the Indian Penal Code, it criminalizes intentional causing of miscarriage, because if it is not done in good faith, right, for the purpose of saving the life of the women. But this act, the Medical Termination of Pregnancy Act 1971, this law, it allows medical practitioners, right, registered medical practitioners, to carry out abortion under certain specified circumstances. Okay. And the law grants immunity to doctors who are performing abortions in accordance with the provisions, right, from the prosecution under section 312 of the IPC, right? But please remember that the law does not give absolute right to women to abortion, okay? Because abortion is permitted on medical opinion, and that too under certain circumstances and to a specified limit. Now see, coming to the Act, Section 2, Clause AA, it talks about medical board. Okay, so a medical board is constituted under Section 3, subsection 2C of the Act. Basically, what happened, this particular Section 2, Clause AA, that talks about medical board, it was not there in the Medical Termination of Pregnancy Act 1971, but it was inserted by an amendment. And there was an amendment in the Medical Termination of Pregnancy Act 1971, and it is called the amendment is called the Medical Termination of Pregnancy Amendment Act 2021. So basically this amendment came into existence in 2021 and this amendment inserted the definition of medical board that is constituted under section 3 subsection 2C. All right. Now see, another section that was inserted by the Amendment Act 2021 is Section 2 Clause E. Okay. It talks about termination of pregnancy. And what does it mean? It means a procedure to terminate a pregnancy by using medical or surgical methods. Right? So that means termination of pregnancy means that a pregnancy, if it is terminated, it can be terminated by medical or surgical methods and procedure. So both these sections were inserted by the Medical Termination of Pregnancy Amendment Act 2021. Now see, there is section 2B which talks about mentally ill person. That means a person who is in need of treatment by reason of any mental disorder other than mental retardation. So basically this definition was already included in the Medical Termination of Pregnancy Act 2000 Medical Termination of Pregnancy Act 1971. Okay, moving to the next slide. Section 3 of the Medical Termination of Pregnancy Act 1971 provides when pregnancies may be terminated by registered medical practitioners. Now, see, the title itself is telling us that only registered medical practitioners can carry out abortions, right? They can only terminate the pregnancy. No person other than the registered medical practitioners can terminate the pregnancy. Now, see, the first point that I have mentioned in my slide is notwithstanding anything contained in the Indian Penal Code, a registered medical practitioner shall not be guilty of any offense under that code or under any other law for the time being in force if any pregnancy is terminated by him in accordance with the provisions of this act. As I already told you in the beginning of my lecture that if registered medical practitioner carries out abortion under certain specified circumstances, then the law grants immunity to doctors, right, for performing abortions, and they are not punishable. They are not punished under section 312 of the Indian Penal Code. All right. Now, section 3, clause 2, subclause 2 says, subject to the provisions of subsection 4, a pregnancy may be terminated by a registered medical practitioner, A, where the length of the pregnancy does not exceed 20 weeks, right? If such medical practitioner is, or where the length of the pregnancy exceeds 20 weeks but does not exceed 24 weeks in case of such category of women as may be prescribed by rules made under this act, if not less than two registered medical practitioners are of the opinion formed in good faith that number 1, the continuance of the pregnancy would involve a risk to the life of the pregnant woman or of grave injury to her physical or mental health, or second point, there is a substantial risk that if the child were born it would suffer from any serious physical or mental abnormality. Now see, as we can see, if we interpret section 3, then we can see that section 3 is also talking about upper limit for abortion, right? So in 1971 the upper limit for abortion was 20 weeks, right? As you can see, point number 2, a pregnancy may be terminated by a registered medical practitioner, A, where the length of the pregnancy does not exceed 20 weeks, right? So this was a scenario under 1971 act. But after the 2021 amendment, now abortion is permissible up to 24 weeks, right, in cases of women under specified circumstances, specified conditions, right? And also after the 2021 amendment there is no upper limit for abortion, right? If you can see section 3 clause 2 point number B, uh, there is no upper limit for abortion if substantial fetal abnormalities are diagnosed by a medical board, right? So also various changes have been made. For example, by the Amendment Act of 2021, the medical opinion of only one doctor is needed to terminate pregnancy up to 20 weeks, right? Before that, pregnancy up to only 12 weeks could have been terminated with the opinion of one doctor. And by the 2021 amendment, opinion of two doctors are needed only for pregnancies between 20 and 24 weeks, right? But the opinion of a four-member medical board is required to terminate pregnancy anytime if there is a ground of substantial fetal abnormalities, right? I have mentioned this in the upcoming slides, right? Now see, explanation to section 3 saying that For the purposes of Clause A, where any pregnancy occurs as a result of failure of any device or method used by any woman or her partner for the purpose of limiting the number of children or preventing pregnancy, the anguish caused by such pregnancy may be presumed to constitute a grave injury to the mental health of the pregnant woman. Obviously, as you have seen in section 3, clause 2, subclause 2, right? Can you see the point number 2 and this point B, right? Where I have written the continuance of the pregnancy, the last lines. The continuance of the pregnancy would involve a risk to the life of the pregnant woman or of grave injury to her physical or mental health, right? Now, explanation to these sections are talking about, what will constitute a grave injury. So that means if, any pregnancy occurs because of result of failure of any device or method that was used by a woman or a partner, right, to limit the number of children or to prevent pregnancy, and if it resulted into failure, right, so this anguish will also constitute a grave injury to the mental health of that pregnant woman, right. Similarly, explanation 2 says that, for the purposes of clause A and B, where any pregnancy is alleged by the pregnant woman to have been caused by rape, the anguish caused by the pregnancy shall be presumed to constitute a grave injury to the mental health of the pregnant woman. Obviously, if sexual assault, rape has been committed, and if a woman becomes pregnant, then also, that anguish that is caused by that pregnancy, it is also presumed that that will constitute a grave injury to the mental health of the pregnant women. So these two explanations are, attached to section 3. Moving ahead, now see, section 3, clause 2A, it talks about the norms for the registered medical practitioner, right, whose opinion is required for termination of pregnancy at different gestational age shall be such as may be prescribed by rules made under this act. That means the act prescribes some norms for the registered medical practitioners, and their opinion is required before termination of pregnancy at different gestational age. All right, but as the conditions and norms should be as prescribed by this act. Section 3, clause 2b also says that the provisions of subsection 2 relating to the length of the pregnancy shall not apply to the termination of pregnancy by the medical practitioner where such termination is necessitated by the diagnosis of any of the substantial fetal abnormalities diagnosed by a medical board. All right. So this means that, the above provisions that we have seen, they will not apply if the medical practitioner is of the opinion that, there is diagnosis of substantial fetal abnormalities, right? Then we will, the provisions of subsection 2 will not be applicable. All right. Section 3, clause 2c, it talks about medical board. Now see, this medical board, this has been inserted by the Medical Termination of Pregnancy Amendment Act 2021, right? And it says that every state government or union territory, as the case may be, shall by notification in the official gazette constitute a board to be called a medical board for the purposes of this act to exercise such powers and functions as may be prescribed by rules made under this act. This means that, the medical board that will be constituted under this act, it will work according to the provisions of this act and the rules which have been made under this present act. Okay, coming to section 3, clause 2d, it says that the medical practitioner shall consist of the following, namely a gynecologist, a pediatrician, a radiologist or sonologist, and such other number of members as may be notified in the official gazette by the state government or union territory as the case may be. So this means that, the medical board shall consist of the following people, right? Gynecologist, a pediatrician, someone who is a radiologist or sonologist, and such number of members that will be notified by the official gazette. Okay. Now, see, moving ahead, uh, in October 2021, the government, it notified the Medical Termination of Pregnancy Amendment Rules 2021, right? So, in these rules, the rules have mentioned the categories of women who are eligible for abortion of pregnancy up to 24 weeks, right? They are: number one, survivors of sexual assault or rape or incest, minors, right? C, change of marital status during the ongoing pregnancy, widowhood, and divorce, right? D, women with physical disabilities, right? E, mentally ill women, including mental retardation. F, the fetal malformation that has substantial risk of being incompatible with life, or if the child is born, it may suffer from such physical or mental abnormalities to be seriously handicapped. And the last point, women with pregnancy in humanitarian settings or disaster or emergency situations as may be declared by the government. So basically, these are the 7 points, which 7 categories, right, under which women are eligible for abortion of pregnancy up to 24 weeks. And these categories have been notified by the Medical Termination of Pregnancy Amendment Rules of 2021, right? So basically, the act does not specify, that the women who is choosing to undergo abortion must be married, right? It does not lay down any condition regarding spousal consent in case of married women, right? But in case of minor, obviously the consent of guardian is required. Okay, and the point, if we can see the point number C, it says that change of marital status during the ongoing pregnancy, right? It means that, after the 2021 amendment, a woman who becomes a widow, right, or divorcee during ongoing pregnancy, a widow or divorcee can seek abortion up to 24 weeks. So, change of marital status during pregnancy is also now a ground for abortion, right? A women with physical disabilities, right? As per the Rights of Persons with Disabilities Act 2020, 2016, mentally ill women, right? And women who is mentally retarded can seek abortion. Fetal malformation is such that, there's a risk of life, right? And if even if the child is born, that child may suffer from physical or mental abnormalities, right? Like handicap, etc. Then also, there is, you know abortion of pregnancy up to 24 weeks is allowed. The last point, which says that women with pregnancy in humanitarian settings or disaster or emergency situations can also undergo abortion of pregnancy up to 24 weeks, right? So these are the grounds, which have been included by the rules of 2021. Now coming to section 4. Section 4 is talking about place where pregnancy may be terminated, right? Now, Section 4 says that no termination of pregnancy shall be made in accordance with this act at any place other than number A hospital established or maintained by government. That means pregnancy can only be terminated at a hospital that is established or maintained by government, or B, a place for the time being approved for the purpose of this act by government or a district level committee. That means pregnancy can be terminated at any place that is a hospital or a place, that has been approved by a government or a district level committee. Okay, and that has been constituted by the government with the chief medical officer or district health officer as the chairperson of the district level committee, right? And this district level committee shall consist of not less than 3 and not more than 5 members, including the chairperson, as the government may specify from time to time. So other than these places, pregnancy cannot be terminated anywhere else. Okay, now see, coming to section 5, it says section 3 and 4 when not to apply. So where, section 3 and 4 are not applicable, these provisions are mentioned under section 5 of the Medical Termination of Pregnancy Act 1971. The first point says the provisions of section 4 and so much of the provisions of subsection 2 of section 3 as relate to the length of the pregnancy and the opinion of not less than 2 registered medical practitioners shall not apply to the termination of a pregnancy by a registered medical practitioner in a case where he is of the opinion, formed in good faith, that the termination of such pregnancy is immediately necessary to save the life of the pregnant women. So basically this provision says that section 3 and 4 will not apply, related to termination of pregnancy by a registered medical practitioner. If that registered medical practitioner, he forms opinion in good faith that it is immediately necessary to terminate pregnancy so as to save the life of the pregnant women. All right. And please remember the point, point number 2, that is section 5 clause 2, is says that if, notwithstanding anything contained in the Indian Penal Code, the termination of pregnancy by a person who is not a registered medical practitioner shall be an offense. That means if a person who is not a registered medical practitioner, right, if he terminates the pregnancy, that will constitute an offense. And please remember, punishment is also prescribed under this section, right? As we can see, punishable with rigorous imprisonment for a term which shall not be less than 2 years, but which may extend to 7 years under that code, and that code shall to this extent stand modified, right? So that means it will be an offense, right? And rigorous imprisonment is there, right? Now 5 clause 3 says whoever terminates any pregnancy in a place other than that mentioned in section 4, as we have seen in the previous slide, right? A hospital, or a place formed by a government or a district level committee. So if there is termination of pregnancy other than places mentioned under section 4, shall be punishable with rigorous imprisonment for a term which shall not be less than 2 years, but which may extend to 7 years. So if you violate section 4, that is also an offense and it is punishable, right? Then it's the next point is 5 clause, section 5 clause 4. Any person being owner of a place which is not approved under clause B of section 4 shall be punishable with rigorous imprisonment for a term which shall not be less than 2 years, but which may extend to 7 years. That means a person, right, who is a owner of a place that is not approved under section 4 clause B, so, that is also an offense and that will be punishable with rigorous imprisonment for a term which shall not be less than 2 years, and that can extend up to 7 years. Okay. Now see, section 5A. Now this section 5A is, trying to give protection to privacy of women, right? How? Section 5A clause 1 says, no registered medical practitioner shall reveal the name and other particulars of a woman whose pregnancy has been terminated under this act, except to a person authorized by any law for the time being in force, right? That means a person who is, a registered medical practitioner, they will not reveal the name and, other particulars related to a woman whose pregnancy has been terminated, right? Obviously, exception to a person authorized by any law for the time being in force. Other than that, a registered medical practitioner cannot reveal the name and particulars of a woman whose pregnancy has been terminated, right? And clause 2 says that, whoever contravenes the provisions of subsection 1 shall be punishable with imprisonment which may extend to 1 year, or with fine, or with both, right? So if you contravene section 5A clause 1 and reveal the name of a woman whose pregnancy is terminated, that will constitute an offense and it is punishable with imprisonment which may extend to 1 year, or with fine, or with both. Okay, so section 5 is trying to give protection to privacy of women. Now see, section 6 is talking about power to make rules, and it says that the central government may, by notification in the official gazette, make rules to carry out the provisions of this act, right? This means that, the central government has power to make rules related to the Medical Termination of Pregnancy Act 1971. Okay, In particular, and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely A. The experience or training or both, which a registered medical practitioner shall have if he intends to terminate any pregnancy under this act. Easy provision. It means that the central government has power to make rules related to experience or training, or experience and training of a registered medical practitioner, right? Because registered medical practitioner will carry out the termination of any pregnancy as per this act, right? As you can read section 2 clause AA, the category of women under clause B of subsection 2 of section 3. So the central government has power to make rules as per section 2 clause AA, section 2 clause AB, the norms for the registered medical practitioner whose opinion is required for termination of pregnancy at different gestational age. Here also the central government can by notification make rules. Section 2 clause AC, the powers and functions of the medical board, right? So the central government there also has power to make rules with respect to the medical board that has been constituted under section 3 subsection 2C, which we had discussed in the previous slides. Now see, the most important part, coming to the judicial intervention. See, in the previous video also, where we had discussed the objective and purpose of the act, we had discussed that article 21 of the Constitution of India, which talks about personal liberty, right? So personal liberty also includes right to make reproductive choices, right? And it is one of the facet of personal liberty under article 21. And it this has been emphasized by various high courts and by various rulings of the Supreme Court as well. So in 2020, Division Bench of Kerala High Court, it passed an order and it observed that a woman has a right to make reproductive choices, and that is a facet of personal liberty, right? Even when the ceiling limit for abortion was 20 weeks before the 2021 amendments, the high courts across the country have passed several orders permitting termination of pregnancy above 20 weeks in exceptional cases, right, relating to rape or fetal abnormalities. So right to make reproductive choice is a facet under article 21, right? And several writ petitions have also been filed in various courts, right, like Kerala High Court, Karnataka High Court, Uttarakhand High Court, where uh, they have sought permission for aborting pregnancies at gestational age, right, beyond the permissible limit on the grounds of fetal abnormalities or pregnancies caused due to sexual violence, right? And you know, in 2021, the Calcutta High Court also allowed termination of a 35-week fetus on the ground of severe abnormalities, right? In the previous video, we had discussed Suchita Srivastava versus Chandigarh administration, right? In that case, the Supreme Court held that, right of a mentally challenged person to choose to continue with pregnancy, right? So in that case, the Supreme Court found fault, with a direction issued by the Punjab and Haryana High Court to terminate the pregnancy of a mentally challenged woman who was allegedly a rape victim, right? Despite the women expressing the willingness to continue with the pregnancy, right? So in that case, the Supreme Court has held that the victim's pregnancy cannot be terminated without her consent, and proceeding with the same would not have served her best interest, right? Because the language of this medical termination of pregnancy act clearly respects the personal autonomy of mentally retarded persons, right, who are above the age of majority. So basically, in Suchita Srivastava versus Chandigarh administration, this was held by the Supreme Court of India. All right. So please remember that, with time to time, there has been judicial intervention by different high courts, Supreme Courts, and the right to make reproductive choices has been emphasized time to time. So these are some of the important provisions of the Medical Termination of Pregnancy Act 1971, along with the Medical Termination of Pregnancy Amendment Act 2021. Thank you for watching this video. If in case you have any doubt, you can just write it in the comment box. Thank you so much.